Good afternoon. I'm Tom Bothwell. I'd like to talk to you about your Social Security hearing. If we're showing you this message, it's probably because your hearing, after months or perhaps a year or more of delay, is finally getting scheduled. It's our hope that this message will help prepare you for the hearing, perhaps and hopefully put you at ease, and to take away some of the mystery of what this hearing is all about, so that you'll go into it understanding better what's going to happen. These Social Security hearings are not like courtroom TV, either courtroom TV that you see on TV, or even real life courtroom. For example, there is no jury. There's no lawyer on the other side. There's no prosecutor or lawyer for the Social Security Administration trying to show that you're not disabled. This is basically between us and the judge. The setting is more informal than real life courtroom. There's no jury. It's just between us and the judge. And there aren't the kind of formalities that there are in court. Before we walk into the hearing room, the judge will have already reviewed the file about you. So when we walk in there, he or she will think he knows a lot about you. The file includes medical reports from your doctors and other sources. We have sent much of that information to the judge, and the Social Security Administration has also gathered some of those records. These hearings are private. The door will be closed. I'm hoping that you will understand that the hearings are confidential and that you'll be willing to talk about your health problems. This is not the time to be scared about or afraid or unwilling to talk about your health problems. There are lots of times in our society or our culture where if someone says, "Hello, how are you?" you're supposed to say, "I'm fine, how are you?" And it's regarded as impolite or just not right to talk about your health problems. But this is not one of those situations. The judge needs to understand what kind of health problems you have that make you unable to work. When we first walk into the hearing, the judge and I usually talk lawyer talk back and forth to make sure that all the paperwork is in order. He'll ask whether I've reviewed the file and whether I have any objections to any of the reports. You can just sit back and watch that happen. And then after that occurs, the judge will start talking to you. He or she will introduce himself or herself, explain that the judge has had nothing to do with the prior decisions in which you've been turned down, and that he or she will make a new decision based upon a combination of all the medical reports which are in the file, plus what is said at the hearing. There may be one or two or perhaps three other people in the hearing room. These hearings are tape recorded, and typically the judge will have an assistant there operating the tape recorder. There may also be either what is called a vocational expert or a doctor or other kind of medical expert. If the medical expert or a vocational expert is at the hearing, that person is there at the request of the judge. That person is being paid for by the Social Security Administration, and usually that person is there because the judge thinks that there may be some questions that come up at the hearing that person with his or her expertise may be able to answer. That person will typically not be talking to you directly. That person will just answer questions from the judge or questions from me. The way that the judge gets information from you at this hearing is by you answering questions. You're not expected to walk into the hearing with a speech prepared to convince the judge about why you're not disabled. The judge understands you're not a lawyer or a doctor, and you don't talk lawyer talk, and you don't have the medical expertise to talk about your medical problems the way your doctors do. Your job is simply to answer questions. So let's talk about what those questions might be or how that process works. Some judges start the hearing by asking you questions, and some judges will look at me and say, okay, Mr. Bothwell, you can start asking your client some questions. Either way, whether the questions come from the judge or from me, I have the following advice. Just listen to the question carefully. Some questions can be answered by saying yes or no. Some questions need some explanation. For example, the judge may ask you just an open-ended question, such as, tell me why you feel like you can't work. That obviously is a question that can't be answered by a simple yes or no. Just try to take your time and explain to the judge why you feel you can't work, what kind of health problems you have that prevent you from working, what kinds of things you used to do when you worked that you can no longer do, and why, and so on and so forth. Just to tell the truth, the obvious part of that is don't make things sound worse than they are. To use a silly example, if you go in there and say you need a wheelchair to get around, but if you really haven't needed that, the judge will probably look at you and say he's read all the medical reports and there's nothing in there about any wheelchair, and he thinks you're lying, and so you lose your case. That's the obvious part of just telling the truth. But the other part of it that I think is just as important is you need to tell it like it is. As I said before, this is not the time to be afraid to talk about your health problems. What I hope for you is that the next day after the hearing, or the week after, or maybe after you get the judge's decision, I hope you don't say, oh gee, I wish I'd been willing to explain better and open up and to talk about my problems. I want the judge to get it. It's your job and my job to help the judge get it. All these judges have different personalities. Some are very friendly. They'll make you laugh or smile, and they'll try to say things in the beginning especially to put you at ease. Other judges, it's just that their personality isn't that way, and you won't walk away from the hearing perhaps thinking, oh, what a nice person that was, or what a warm and fuzzy individual. But I believe in this system enough that I believe the judge wants to get it, wants to understand why you feel like you can't work. The judge will work hard at reading the medical reports to understand your problems. We don't have judges who feel that if they approve too many cases, the money will come out of their pocket. I believe that the judge will have no problem whatsoever approving your claim for disability if we can prove that you can't work. Don't worry about specific details like exactly what day of the week or what month you last worked. At these hearings, you're not expected to remember the kind of trivial questions. You will be asked questions about approximately when did you last work, that kind of thing. Just answer the question as best as you can. If you're asked a question where you can't remember the answer, really, then just say, I'm sorry, Judge, I can't remember. Sometimes we have health problems that make it harder for us to remember. Sometimes we take medication that impairs our ability to remember. And if that's what's going on with you, feel free to explain that to the judge. These hearings usually take less than an hour. It's unusual we've waited so long for this hearing, many months, often more than a year, and then when we finally get to the hearing usually lasts less than an hour. Sometimes, believe it or not, the hearing just lasts something like 10 or 15 minutes. If the judge has reviewed the file and he or she decides that there are just a few questions that need to be answered, it might take a short time like that. The longest hearing that I've ever had in doing this for more than 30 years was about an hour and a half. So I think you can plan on your hearing probably taking less than an hour. As far as what to wear, it's not necessary for the men to wear a coat and tie, or the women to wear a skirt. You should just wear clean clothes, and you don't have to be very formal. I want the judge to see that you're a good person. I want the judge to see that if you could be working, you would be working, but you can't, and therefore you need his help. Of course, be respectful. If it seems to you like the judge has gotten off on the wrong side of the bed or what have you, and he or she is a little ornery that day, it won't do you any good to try to lock horns with the judge. So if the judge says something that is perhaps offensive to you, just try to let it roll off your back, because it truly won't do you any good to get into an argument or something like that with the judge. As I say, I just want the judge to see you're a good person, and I want him to believe you, and I want the judge to understand that you are telling the truth when you explain why you can't work. I'd like to talk to you now about some of the common questions that come up at these hearings. These questions may not come up in your hearing, or all of these questions may not come up in your hearing. As I say, sometimes these things are quite short, but I'd like to give you some idea of the kinds of questions that you'll be asked. To begin with, you'll probably be asked if you're currently working. More commonly, you'll be asked, when's the last time you worked? Again, as I say, don't worry about a specific date, just try to estimate when you last worked. It may be more than months ago, it may be a year or more ago. You'll also be asked, what kind of work did you do? And why did that job end? Were you fired? Did you quit? Were you unable to do certain things? And if so, what? We have to show, to begin with, the first thing we have to show is why you are not able to return to any of the jobs that you've had in the past. Not so much the distant, far past. Social Security has a 15-year rule where the judge will be asking you questions about what kind of jobs have you had in the past 15 years. So do your best to try to remember what kind of jobs you've had. You don't need to know or remember the name of the particular employer, but the important thing to describe to the judge if you're asked about this is what kind of jobs, what kind of job titles, and what things did you do in your work if you've had jobs in the past 15 years. And remember that in part of this process, we'll be having to explain why you are no longer able to return to and do that kind of work anymore. One thing that I need to explain that I wish it weren't so, but I need to caution you about how you describe what kind of work you've done in the past. This is not a job interview where typically we try to enthusiastically convince the listener that we can do practically anything if we're just given an opportunity. This is a time where, again, I remind you to tell the truth, but this at the hearing will not be a good time for you to exaggerate what kind of experience you have acquired in your past work. Whether this is fair or not, the rules about these things are that the more experience you have, the more skills you have, the more different things that you can do as far as work is concerned, it may be harder for you to get approved. A person, for example, who's 55 years old, who has had only unskilled work experience with no education or not much of an education, if that person, for example, has a broken back or has had back surgery and can't do that kind of work anymore, it is often easier for us to get that person approved than someone who's of the same age but who has lots of education and who has had lots of experience in jobs, working desk jobs or things such as that which aren't hard physically. And I don't want this judge to get a wrong impression about what kind of experience you have had. So again, with a reminder to tell the truth, but this is not the time to puff up or exaggerate your skills. Because if the judge gets a wrong impression, thinking that you do have more skills than you really do, it may be even harder for you to be approved. Another kind of question that frequently comes up at these hearings is the judge or me asking you to describe your average day. For example, with questions like, when do you typically get up in the morning? When do you typically go to bed in the evening? And what do you do in the meantime? In asking those questions, the judge or I are wanting you to explain and to tell the judge basically how active you are. What kinds of things do you do around the house, if any? Who does the household chores? The judge wants to figure out what you can do even if you're not working. So again, this is not the time to be too proud to admit that you're not able to do very much at home if that's the case. Many people who are applying for Social Security disability benefits need to lay down some during the day, whether it's lay down in a bed or get horizontal on a couch or get in the old lazy boy, that kind of thing. If you need to do that typically on an average day, if you usually are not able to go, for example, from 8 in the morning until 5 p.m., the kind of hours associated with a normal workday shift, without needing to lay down, it's important that you explain that to the judge. Because if the judge understands that you really need to do that, whether it's because of pain or because you can't sleep at night because of your health problems, or perhaps side effects of medication, if the judge understands that you're not able to go those 8 or 9 hours from 8 to 5 or 9 to 5 without needing to lay down, that alone may be a reason why the judge will approve you. I mentioned side effects of medications. Oftentimes, medication that a doctor prescribes for you in order to help you with your pain or to control the symptoms of some of your medical problems, oftentimes those medications have side effects which would make it even harder for you to work. Pain medication often makes it hard for us to think straight. Pain medication often makes us drowsy, makes us sleepy, and makes us need to lay down some during the day. Other medications have different side effects. You may be asked by the judge, do your medications give you any side effects? If the judge asks you that question, that's what he's trying to figure out. He's trying to figure out whether you take any medication which has side effects which make it harder for you to work. When a judge decides whether or not to approve you for disability benefits, he has to take all of these things into consideration. Your age, your education, your previous work experience, all of your medical problems, side effects of medication, not just physical problems. Of course, the common physical problems such as bad backs or diabetes or heart problems, but also emotional problems. If you're suffering from depression or anxiety, we'll need to talk about that. The judge needs to understand if those things are going on. I've won many cases for many clients who have nothing wrong with them physically at all, but they're suffering from serious depression or anxiety or other kinds of emotional or what they call mental impairments, which make it impossible for them to work. I know it's no fun to talk about these things, I again remind you the door will be closed. These hearings are confidential. No one will hear about what you say at these hearings, but we do need to explain to the judge why you are unable to work. Another line of questioning that is common at these hearings is for the judge or for me to ask you about how much you can lift or carry. The judge may want to know whether you can carry things that are 10 or 15 or 20 pounds or heavier. A lot of us don't think in terms of how many pounds can we lift at one time. So I'll just give you an example. A gallon of milk or water weighs about 8.5 pounds. So if you think about that and think about, could you lift and carry 1 or 2 gallons of milk or water, if you had, not just to pick it up one time, but if you had to do something during the day which would require you to pick up that kind of weight frequently. Of course, tell the judge if you can, but even though 10 pounds doesn't sound like very much, if carrying that kind of weight of a gallon of water or milk, as an example, would be difficult for you, whether your back or your shoulder or whatever, then try to explain that to the judge. Lastly, I'd like to speak a bit about the process of what happens at the end of the hearing. Sometimes at the end of the hearing, the judge will say whether or not he or she will approve you, but oftentimes the judge does not say that clearly. About half the time at the end of these hearings, I think I know what the judge is going to do, and if I know that based upon what was said at the hearing, I will tell you that afterwards. But many times we just have to wait for the decision. Typically these judges come from out of town, do one hearing after another all day for about 4 or 5 days during the week, and then they go back to their office and send out their decisions. Nothing is official until it's in writing. We usually have to wait anywhere from 2 weeks to 2 or 3 months sometimes for the written decision. As soon as it's received, you and I can talk about it. If the decision is favorable, it usually then takes other parts of the Social Security Administration 2 or 3 months at a minimum to do the calculating and figuring out how much retroactive or past due money you'll be eligible for and how much you will receive each month as a monthly check. If the decision is unfavorable, we have a right to appeal, and we'll talk about that. I hope this message has been helpful to you. It is my plan that after you watch this message, we'll talk about it, and I'll ask you if you have any questions, and we can talk about some more particularities or circumstances of your particular case. But thank you again for giving me the opportunity to help you. Thank you.